As we conclude our study of property management, we move from the administrative responsibilities of record retention to a specific, often misunderstood topic: the lawful payment of finder fees to apartment tenants. Finder fees are small monetary incentives that property owners or managers may offer to current tenants who refer new tenants to their rental communities. While common in multifamily housing marketing, such payments must strictly comply with Arizona real estate law to ensure that they do not constitute unlicensed real estate activity or unlawful compensation. The regulation governing this area is found in ARS Section 32.2176, which clearly defines the circumstances under which an apartment tenant may lawfully receive compensation for referring another prospective tenant. Under this statute, a finder is someone who introduces or refers a person to a property but does not engage in any acts that require a real estate license, such as negotiating rental terms, presenting lease agreements, collecting payments, or showing the property. Essentially, the tenant may act as a source of a lead, but may not perform any function that falls under the statutory definition of real estate activity. To ensure compliance, several key limitations are established by law. First, the tenant must reside in the apartment complex being promoted. Second, the payment must come directly from the property owner or the owner's licensed property management firm, not from another tenant or third party. Third, the finder fee must be paid in non-cash form, such as a rent credit, gift card, or voucher. Direct cash payments to tenants are prohibited because they could be interpreted as commission-like compensation. The rule limiting a finder's fee for an apartment lease referral by an unlicensed tenant to $200 was a specific provision of Arizona law that has since been modified, and there has never been a federal rule imposing a universal $200 cap on such fees. Prior to August 2017, Arizona law restricted these referral fees to a maximum of $200 in rent credit per referral, up to 5 times per year. However, current Arizona law, found in ARS Section 322176, now allows property owners and property management firms to provide unlimited finder's fees to existing tenants in an apartment complex for referring new residents, provided the compensation is given solely as a credit toward or reduction of the tenant's rent. The tenant receiving the finder's fee must limit their involvement strictly to making the referral by providing names or contact information, and is expressly prohibited from showing the unit, discussing lease terms or conditions, or participating in lease negotiations. For example, imagine a tenant named Lisa, who lives in a large apartment community in Scottsdale. She refers her co-worker, Sarah, who subsequently signs a 12-month lease with the same property. The property manager, following ARS Section 32-2176, offers Lisa a $150 rent credit on her next monthly payment as a lawful finder fee. Lisa's role was limited to referring Sarah and not participating in any lease negotiations. However, if Lisa were to regularly advertise available units, collect deposits, or quote lease terms to potential renters, her actions would exceed the scope of the statute and would require a real estate license. The rationale behind this law is to encourage tenant referrals, a valuable marketing tool, while preserving the integrity of professional real estate practice. Allowing tenants to earn limited non-cash rewards for referrals supports community engagement and reduces vacancy rates for landlords. However, by restricting the type and amount of compensation, the legislature prevents unlicensed individuals from engaging in real estate brokerage without oversight or accountability. Violations of ARS Section 32-2176 can have serious consequences for both property managers and tenants. If a manager pays a tenant an unlawful finder fee, such as a cash payment or multiple payments without record keeping, it constitutes aiding and abetting unlicensed activity, a violation of Arizona Revised Statutes, Section 322155C. Likewise, if a tenant accepts compensation for performing acts that require a license, both parties could face penalties. To maintain transparency, all finder fee payments must be properly documented in the broker's property management records. The payment should be recorded in both the property owner's and tenant's ledgers, noting the amount, form, and purpose of the incentive. According to ARS Section 2175B, these records must be retained for 3 years after the payment is made, or until the records are given to the owner at the termination of the property management agreement. Just like all other property management transactions, records must be kept in case of issues in after termination. Review summary. Finder fees provide a lawful and ethical way for property managers to reward tenants for referring new renters. If done within Arizona's legal framework, tenants may receive non-cash compensation up to $200 per referral, no more than 5 times per year, and only when their involvement is limited to introducing prospective tenants. Cash payments, negotiating lease terms, or quoting rents without a real estate license are strictly prohibited. Property managers must document all finder fee transactions, ensure compliance with statutory limits, and avoid any actions that could be construed as aiding unlicensed real estate activity pursuant to ARS Section 2155C. Discussion. Prompts under current Arizona law. How did the rules governing finders' fees paid to apartment tenants for referring new residents change? And what restrictions still apply to the tenant's involvement in the leasing process? Answer. Arizona law previously limited finders' fees to $200 per referral, up to 5 times per year. But ARS Section 32-2176 now allows property owners and property management firms to provide unlimited finders' fees to existing tenants, as long as the compensation is given solely as a rent credit or reduction. What is the maximum allowable finder fee that a tenant may receive under ARS? Section 32-2176. Answer. There is no limit for a finder fee and can be given multiple times, and only in non-cash form. What record-keeping requirement applies to finder fee payments? Answer. Property management firms shall keep records of all finder fees that are paid to tenants for 3 years after the payment is made, or until the records are given to the owner at the termination of the property management agreement. ARS Section 32-2175B. Closing remarks. The lawful use of finder fees represents a delicate balance between encouraging community participation and maintaining the integrity of licensed real estate practice. By following the statutory guidelines under ARS Section 322176, brokers and property managers can safely implement referral programs without crossing into unlicensed activity. Ethical and compliant administration of these programs not only protects licensees from disciplinary action, but also promotes a positive, collaborative environment within rental communities. Proper documentation, transparency, and adherence to limits are key to ensuring that finder fee practices remain a legitimate part of Arizona property management.